civilian combatant and the notion of direct participation in hostilities strikes to the core of international humanitarian law and challenges faced on the battlefield. It is my pleasure to serve as chair with two distinguished and learned panelists before us today. The topic, ladies and gentlemen, requires an appreciation of the evolution of international humanitarian law from contemporary armed conflict, which witnessed a change of rules codified in the 1907 Hague Rules, regulating the conduct of hostilities, but more so why the regulation of the conduct of hostilities. We realized that perhaps Solferino and battles which followed witnessed in most part a disproportionate effect on members of the armed forces. We saw this coming out, ladies and gentlemen, in the passage of the 1929 Geneva Conventions, and even a large emphasis on the 49 Conventions. However, in 1949, global society witnessed a change in the codification of the protection of another group of individuals affected by armed conflict. And this became crystallized in law via the Fourth Geneva Convention, that which seeks to protect civilians. Well, since 1949, you would agree with me that a lot has changed in respect of the nature of armed conflict and those who have been affected by armed conflict. And today, the majority of armed conflicts, albeit non-international in nature, by and large, result in a disproportionate effect on this category contained within the Fourth Geneva Conventions. And of course, we speak of civilians. We speak of persons who do not participate in hostilities. The purpose for this agenda setting, ladies and gentlemen, is because the term civilian, in practice, has perhaps a different connotation. You know, IHL is often accused as being two steps behind what really takes place on the battlefield. It is how the law has developed in respect of the law of war. And so as chair, it is of great interest to consider how and to what extent has the civilian in armed conflict changed over the years. And in my humble view as chair, this fits squarely within the topic of direct participation in hostilities. And the reason to clarify, much less identify, the civilian combatant notion. And so, speaking as chair, but also as an officer of the ICRC, I refer to an interpretive guidance, which seeks to bring some clarity towards the direct participation in hostilities argument. And this is known as an interpretive guidance on DPH. I say no more in substance on this guidance, but to say it is not a perfect document. I refer to the New York Law Journal, 2010, 6 months after the publication of this guidance document, which pokes many holes, by Anglo-Saxon and other experts in a guidance document. Some say it's too permissive, others say it's too restrictive. Have we understood how, if at all, IHL seeks to protect civilians? And does it in fact protect it? And in the spirit of independence, as an organization which seeks to promote and develop international humanitarian law, are we being honest with ourselves that IHL is being applied fairly to combatants and to civilians alike? These are just some questions I put to members of the panel. And so it is my honor and pleasure to introduce two speakers. The first is a gentleman who received his primary and secondary education at the Royal College in Colombo, Sri Lanka. He joined the Sri Lankan College in 1976 and was called to the bar as an attorney at law in the Supreme Court in June 1979. In 1980, he joined the Department of Attorney General's office in Sri Lanka as an acting state counsel, promoted to the post of senior state counsel in 1989. Thereafter promoted to Deputy Solicitor General in 1997, and further to Additional Solicitor General with effect from the 5th of January 2007. 4 months later of that year, in May 2007, he was called to the Inner Bar as President's Counsel. appointed as Solicitor General from the 12th of September 2011. He then assumed office as the Attorney General of the Democratic Social Republic of Sri Lanka on the 16th of July 2012. Of course, I speak of Mr. Sarath Talitha Fernando, who joined the volunteer force of the Sri Lankan Navy in the rank of Commander in 1989 and was promoted to the rank of Captain in 1993. Thereafter to Commodore in 1999 and Rear Admiral in July 2007. Mr. Fernando holds a Bachelor of Laws degree from the University of Colombo, a Master of Laws degree from the University of Colombo also, and a Master of Laws also from the University of Bristol. He wears many hats in respect of his relations with the ICRC on professional levels, and today we're pleased to welcome him to this session as Attorney General of Sri Lanka. Welcome, sir.
Members of the head table, ladies and gentlemen, when I was invited to speak today, I was wondering whether I should follow the other speakers and sit there and address you. But then to tell you, to confess to you, I, as Attorney General, am not used to addressing court seated. I always address court standing, so therefore I thought it would be better if I would address you standing, and that is why I stand here today. Now, the topic that has been referred to the panel, in which I am a member, is a topic that has concerned a lot of people, bothered a lot of people, a matter that has been discussed and debated at lots of fora, and also among the armed forces, among civilians, and also professionals from the International Red Cross. Protection of civilians is a matter that was included in international humanitarian law from the inception. Even before the 1864 Convention, the Geneva Convention, protection of civilians during armed conflict was a matter which was accepted without debate. Protection of civilians was included, codified, as Charles said, in the 4th Geneva Convention, and that was only a codification of the general principles or the principles of humanitarian law that existed prior to that. There are several matters that have contributed towards the change of attitude of international humanitarian law, and also the thinking of activists in these areas. And one was the innovations in science and technology. Weapons of mass destruction. Weapons, now including the drones, which we discussed during the previous session, the harm that it could cause, harm which was not proportionate to the harm that was necessary to be caused. All those matters contributed jointly towards the rethinking, restructuring of international humanitarian law, and here we are today discussing this very important matter at this IHL conference. Now, as far as destruction is concerned, all of us know that civilians are caught up in between during fierce fighting, and as a result of that, the damage that is caused, the number of civilian lives and resources consumed is intolerable. And that is why President Eisenhower, President of the United States of America, he said during his inaugural address, during his first inaugural address, he said, "Science seems to offer to mankind as its last gift the power to erase human life from the surface of the planet." When he said that, what he was referring to was the advancement in science and technology and the sophisticated weapons of mass destruction that were being created, and those weapons that were being used at armed conflicts. All of us know that the ideal situation would be if there were no arms, there were no conflicts. But unfortunately, conflicts have been as old as the human race, and we are not any closer to finding a world free of conflict from where we were even during the First World War. Disarmament has been a topic that has been discussed throughout by the United Nations. Disarmament has been one of the major issues which prominently featured in the agenda of the United Nations. But then we have not been able to achieve anything positive during this period. As a result of that, what is important next is that we look at minimizing the damage that is caused to civilians. And all the laws and rules and regulations, including the IHS Conventions, the Geneva Conventions, including the 4th Geneva Convention, all these aim at one important thing, that is minimizing damage that can be caused to non-combatants, to civilians who are caught in between. According to official statistics, during the Second World War, 60% of the casualties were innocent civilians. And that was something that the whole world mourned. That was something the whole world wanted to avoid. And that was something that the world thought that the world should take note of. As a result of that, the whole world today, including the International Red Cross, they have been involved in it for a very long time. They have all come together with one aim, with one thing in mind, and that is how do we minimize civilian casualties during armed conflict. Now this becomes more important because civilian involvement, either voluntarily or involuntarily, direct or indirect or inadvertently, in armed conflict is increasing. I can speak to you from my experience because I come from a country which was torn apart and devastated through a ruthless armed conflict for a period of 30 years. I don't think that anyone in this audience could be more sensitive than I am to armed conflict. When Charles introduced me, I never expected him to introduce me that way. He introduced me as a member of the armed forces also. Yes, I did. I was a member of the Sri Lanka Navy. I was a member of the legal department of the Sri Lanka Navy, and I can tell you of one experience. I had to meet the commander on a particular day, and the commander gave me an appointment at 9 o'clock in the morning. I was there 8:30 ready to meet him. Now this was a gentleman I met the previous day. And while I was waiting to meet him, there was a tremendous explosion. And then we were told that the commander is no more. We went down and I saw that he was torn to bits. This is only one experience, an experience that I saw, which I recognized. Now, not only the commander, he would have been a target of the enemy, but then several civilians, innocent people who were just about the place, torn to pieces. People who would have nothing to do with the war. People who would have nothing to do with the armed conflict, torn to pieces. How many mothers, how many children, how many fathers would have been amongst them? Therefore, it is absolutely necessary that we do whatever possible within ourselves in order to see that civilian casualties are minimized. But then the problem that we are discussing here today is something that is extremely important. That is, how do we distinguish a civilian from a combatant in an armed conflict? As I told you, due to the involvement of civilians more and more in armed conflict, sometimes inadvertently, sometimes without knowing that they are involved in it, sometimes where they happen to be in that particular place, and then they lose the protection that they are given by international humanitarian law by virtue of the fact that they are participating in the armed conflict. Now, as all of us know, direct participation in armed conflict is the situation where you lose the protection that is given to you by international humanitarian law. Non-combatants are protected, civilians are protected, so long as they are not in direct participation and so long as they do not directly participate in the armed conflict. Now this is the distinction that we have to draw, and that is the distinction international humanitarian law wishes us to draw. And that is the interpretation that has been given, the document for the purpose of interpreting, and as Charles said, it's not a complete document, nor is it a flawless document, but it is a document which is in the correct direction, and it is something that we have to take seriously, it is something that we have to look at, it is something that we should try and implement as much as possible, because that gives us certain guidelines as to how we could identify civilians from combatants and how civilians could be protected when they are not in participation or when they are not directly in participation in the armed conflict. Now firstly, let me tell you, one of the important things that the armed forces confront in distinguishing a civilian from a combatant is where there is civilian participation in numerous other ways. Numerous other ways in the sense where civilians perform certain functions for the purpose of armed conflict, sustaining the war, sustaining the enemy. Now in a situation like that, the principles of international humanitarian law is very clear, that you cannot consider the civilian as a combatant if the participation is not direct. If the participation is indirect, then the civilian is entitled to the protection that the civilian should get in terms of international humanitarian law. Now there is no doubt about the participation of certain persons, like religious persons, like medical personnel, like others who provide supplies to the armed forces. They are clearly outside that line where they are not considered persons who are directly involved in the armed conflict. But what is important is there can be a situation where there are certain civilians who fall into a particular category who come into the definition of direct participation as a result of their position, as a result of how they are placed, and as a result of how they get involved or they are connected to the armed conflict. I will give you a few examples, and those examples I give you from the experience that we have undergone. Number one, very unfortunately, civilians are used today as human shields. That was a situation that we had to confront, that was a situation that we had to face. Where human shields, where civilians are used as human shields. Civilians who never want to participate in the confrontation, but then they are forced or compelled under certain circumstances to stand there as human shields, and they are helpless between the warring parties. They are helpless between the two parties which are involved in the armed conflict. In a situation like that, the civilian who is innocent and who is just there can always claim to be protected by international humanitarian law, but then what is the situation in respect to the armed forces who are facing a fierce war, and the commander who has to take the decision at the heat of the moment. Now, on numerous occasions, references were made to the right of private defense, where they are entitled to exercise the right of private defense, where the forces are involved in an attack, and the attack is directed from behind the human shield. Now, what would be the situation in that? How would we interpret the principles of international humanitarian law in order to say that in situation like that, that humanitarian, the principle international humanitarian law should be implemented, or whether international humanitarian laws will have to be ignored in a situation like that simply because no action could be taken without causing any sort of damage to the civilians. Now that is one aspect that I would like to consider. I'm sure Suzanne will have something to say about it during the course of her presentation, but that is one aspect that I'm telling you from the experience that we have undergone, from something we have seen. In those instances, it is expected that the armed forces would avoid as much as possible civilian casualties. But then the decision will have to be taken at a person who is there with the forces, the heat of the moment, the heat and dust of the moment, stressed, facing a situation like that. And in a situation like that, how would you interpret the international humanitarian law principles? Now, another important issue is the concept of preemptive self-defense. Preemptive self-defense is a concept that is accepted. Preemptive self-defense is not where you act for the purpose of self-defense, but where you act in order to preempt an action that might cause you damage or harm you as you go on. Preemptive self-defense is something that has been accepted under international law. There have been instances also, I can mention even one instance. If you take the 6-day war in Israel, where Israel had to go into Arab territory, and the way in which they tried to defend their action was that they had the right to preemptive self-defense, where they proceeded outside their territory in order to take action that would preempt any action that would expose them to danger. Now, preemptive self-defense is a weapon that is used, or that is a tool that is used for the purpose of protecting you where there is a danger that is looming against you. Now, there have been situations where, especially in international national armed conflict, more than international armed conflict, in national domestic armed conflict, where the government forces are at war with an insurgent organization or a terrorist organization, whatever it is, for whatever reason, when they are there. There have been instances where the camps or the groupings of the terrorists is made in a highly populated area among civilians, where you are not in a position to identify civilians from combatants, especially when those people, they are not dressed in any sort of uniform, when they are dressed in civilian dress, and they establish their camp in a particular place. And when that is done, it is a camp of the enemy for all purposes, for all reasons. You cannot distinguish it from anything else because it is a camp of the enemy. But unfortunately, it is established the center of civilians. And any action of preventive self-defense, not targeting the civilians, but targeting the enemy, might cause some sort of damage to the civilians. In those circumstances, would it be possible for us to say that the international humanitarian law principles protecting civilians who are non-combatants, who on that particular occasion were not involved in any sort of armed conflict, directly or indirectly, but due to the place where they were located, they happened to be a target, and any destruction caused to them, would they be protected by the principles of international humanitarian law, where it is very clearly stated that a civilian, so long as it's not in direct participation in the armed conflict, and for so long as he is not in direct participation in armed conflict, then the protection that is afforded under international humanitarian law will have to be given. Now, in a situation like that, how would you interpret it? What is the way in which the armed forces would be entitled to look at it? Now, would they be in violation of principles of international humanitarian law if they exercise the right to preemptive self-defense? Now, in the exercise of preventive self-defense, they do gather information, but then they know that once the information is available to them, they know that this is a camp of the enemy. It is a camp of the enemy. And when they exercise the right to preemptive self-defense, the resulting position is civilians are killed. And when civilians are killed and when that matter is brought to light, the question that arises is international humanitarian law operative in a situation like that? And will it be a situation that will have to be taken into consideration? Before I started my speech, Charles gave me one advice. He said, you should not be dogmatic. That is left to Suzanne. You try to provoke the members of the audience in order to generate their thinking on this matter, so that they could make comments on the issues that you are going to raise. So that is exactly what I'm trying to do on this particular occasion. Now, if you take the principles of international humanitarian law, principles of international humanitarian law protect civilians, of course, and where civilians are not in direct participation in an international armed conflict, then the principles would be operative. But then there are certain instances where a civilian is fully involved in it, fully involved in it, but then he can project himself as a civilian easily. Now the way in which it was described in Secretary General's speech this morning, that is where you are a terrorist, a civilian by morning and a terrorist by night in a situation like that. Now in a situation like that, I agree that principles of international humanitarian law will operate to protect that person from any sort of action by the opposing party, because the purpose of war, purpose of armed conflict is to weaken the enemy and nothing else. And then if whatever action you take doesn't in any way weaken the enemy, and if it amounts to the destruction of civilians, then of course that action cannot be taken. But then when it comes to a domestic armed conflict, I must tell you, the domestic law also operates. Wherever a person is found involved in an armed conflict, but not directly in the armed conflict, but supporting it in some way, then the domestic law is there to punish them. Action can be taken under the domestic law. But what is prohibited is you cannot use force. Using of force against them is what is prohibited by principles of international humanitarian. But that does not prevent the domestic law of the country. The domestic law of the country, now this applies to domestic armed conflicts, domestic laws of the country dealing with them for their participation, though not indirectly in the armed conflict. But as far as principles of international humanitarian law is concerned, principles of humanitarian law will protect any sort of direct violence against them. I don't think that direct violence is used after calculation by any armed force, because terrorizing a civilian population is certainly an offense which has been described as an offense against humanity, a war crime, in terms of the Rome Statute, that is the convention, the Criminal Law Code Convention. Using direct violence for the purpose of terrorizing a civilian population is a war crime. I do not think that that is done calculatedly, purposely, for the purpose of terrorizing a human population. But undoubtedly it happens in the process, and then one reason for that is the sophisticated weapons, the weapons of mass destruction, and also shifting of the arena. Now previously, as someone said this morning, only 10% of the casualties of the First World War were civilians. But then with the passage of time, after the Second World War, and with every passing moment, we see that at every conflict, the number of civilian casualties increase. And then the increasing number of civilian casualties is not always due to direct involvement, but it is due to the involvement of those persons, civilian persons, in the armed conflict as a result of reasons that compel them to be there. Now, two examples that I gave you was, one was where they're used as a human shield. Number two, where a camp or where the activities of the warring party is located in the midst of civilians. In a situation like that, though principles of international humanitarian law do give them the protection that is needed, the members of the armed forces sometimes cannot be faulted, because the way they act can be always justified within the rules of preemptive self-defense or within the rules of action that is beyond their control. Because once they do that, and once they get the civilians, or when some sort of harm is caused to the civilians, that certainly is outside the principles of international humanitarian law, on the basis that it has not been done directly, but it happened as a coincidence, or it is one of the incidental results of the action. Now this, I think, is a matter that has to be taken very seriously. It's a matter that gives a lot of concern to all those who are much in favor of the implementation of the principles of international humanitarian law. However, the identification of the combatant, distinction between the combatant and the civilian, is undoubtedly very difficult to distinguish between the two. But the circumstances in which we are placed are such that in a situation like that, it would be more difficult for us to falter the armed forces for whatever action they have taken if they had overstepped the legitimate limit. Now when the previous session, when the question regarding drones were considered, when it was stated that drones do cause a lot of harm, one of the arguments that was adduced against it was that the drones cause less harm. So what we are trying to do is, I think, all what we can do, and all that is humanly possible within this, is to interpret the international humanitarian law principles in order to ensure that the damage that is caused inadvertently or incidental to the main damage that is intended is minimized. I don't think we could achieve anything more within the limited areas, within the limited boundaries in which we are located right now. One reason is that the shifting of the arena. The arena has now been shifted right into the areas of human population. As a result of that, it could be extremely difficult to implement the principles of international humanitarian law to the letter. But what we should strive at, what we should seek to achieve, is to minimize them within those rules and then try to draft and try to interpret the principles of international humanitarian law, having in mind the rights of those parties involved in the war, in order to protect themselves, protect the civilian population amongst them, and also achieve the target of weakening the enemy as much as possible. It was very correctly stated that killing an enemy or a person involved in an armed conflict is not a crime. Killing the enemy is encouraged. Even a civilian, if he is armed with a lethal weapon, there is no law to prevent him from doing that. So action against them is direct. Direct action against the enemy is accepted. But what is bothering us is that whatever damage that is caused to civilians, and by direct acts of violence have always been prevented. Direct actions of violence have always been discouraged. All the principles of law commencing from 1864, international humanitarian law rules, all those protect the civilians, there is no doubt about it. But what is important here is the action that we take in order to minimize the damage that could be caused to the innocent civilian who is not directly involved, but then the actions of the armed forces are also equally innocent. I think that those are the two extremes between which we should draw the balance, strike a balance, where the actions of the armed forces cannot be faulted, because what they are doing is not something wrong. What they are doing is what they are expected to do as a result of the war. I'm not thinking of a situation where civilians are rounded up and then slaughtered. No, that is not a situation that I'm talking of. I'm talking of a situation where there is a legitimate exercise of armed forces, activity of armed forces, and as a result of that, civilians are caught up, and the catching up of civilians is due to the compulsion that they have to undergo where they are located, and also due to the activities of the armed forces. So finally, Suzanne, I would like you to pay some attention to this, as to how we should strike a balance between legitimate actions of the armed forces and then the innocent civilians who are unprotected as a result of those legitimate actions which are not violative of any of the principles of international humanitarian law. So with those words, I shall end thanking all of you for the attention and for the invitation that was extended to me to speak on this occasion. Thank you.
Thank you very much, Attorney General, and it's not often that as a civilian I would have the chance to be provocative to an HG. So as Chair, I take this opportunity to perhaps continue where you ended, underscoring that in IHL every civilian is assumed to be innocent. And this is the basic premise of the Fourth Geneva Conventions, and it's the very reason for the development of an interpretive guidance which seeks to establish this legal concept of a belligerent nexus, a threshold of harm, a causation element, all of which are necessary in order to perhaps waive the protection conveyed under IHL to a civilian, but to still give a different type of protection, but to that of a combatant. I wish to underscore that the change of status of civilian to perhaps a participant in hostilities doesn't waive protection, but perhaps changes the level of legal protection which has been given. So you have certainly been extremely thought-provoking in terms of the use of human shields rather, voluntarily, involuntarily, the use of using camps which may house a majority of civilians, but perhaps the presence of the armed forces as a legitimate target. You also, sir, raised this use of collateral damage. What is collateral damage insofar as weighing military necessity against that of humanity? More after the presentation rather of Professor Susan Lamb, who of course, as we know, is professor and also vice dean at the Jindal Global Law School, following a 16-year career with various United Nations justice responses to atrocity crimes in the former Yugoslavia, Rwanda, and Cambodia, to name a few. Professor Lamb also served as the Senior Judicial Coordinator to the UN Assistance to the Khmer Rouge Trials and the Senior Legal Officer to the Trial Chamber of the Extraordinary Chambers in the Courts of Cambodia. This was from 2009 to 2013. And thereafter, as Chef de Cabinet to President Eric Moss and Senior Legal Officer to the Trial Chamber No. 1 of the ICTR. Professor Lamb has also served in various capacities with the ICTY between 1997 and 2005, most recently as an appeals counsel. Susan Lamb was a Rhodes Scholar and is admitted to practice as a barrister and solicitor of the High Court of New Zealand. Ladies and gentlemen, Professor Susan Lamb.
Thank you very much for that, for the invitation to speak here and that kind introduction. The topic given today was direct participation in hostilities. As His Excellency the Attorney General has indicated, this is related to the broader question of how does one distinguish between a combatant and a civilian generally. As this audience will need no reminder, sort of civilian status is of course defined negatively, that a civilian is anybody not forming part of the armed forces of a state. But this question asks us to add another layer, in that in the event an individual has or is assumed to have civilian status, how is that protection lost? International humanitarian law emphasizes as perhaps the bedrock norm the inviolability from attack, both direct or indirect, of civilians, closely related to that are principles of distinction between combatants and civilians. But civilians benefit from this protection only unless and for such a time as they refrain from taking a direct part in hostilities. So in the course of this presentation, I'm going to try to elaborate to the extent I can as to the notion of what it means to take a direct part in hostilities and what criteria exist to remove civilians from the protections of a civilian. It's been somehow hinted that I can be relied upon to provide some form of dogmatism or intellectual rigor here. I really regret to inform everyone that my background is really that of a practitioner, and a very particular one at that, from various ad hoc and other internationalized tribunals. And I thought it might be interesting for this audience to draw on some of this practice for several reasons. I think firstly, working in this area in relation to these principles is a little bit of a mixed blessing. I think the first is that these tribunals have provided in practice one of the very few opportunities to actually adjudicate the scope of these provisions under the additional protocols and the Geneva Conventions that form the basis of this discussion. And so the jurisprudence that emerges under this inevitably attract a degree of scrutiny and are interesting. But on the other hand, they tend to be very conservative institutions. And the reasons for that are multiple. The first is that they are first and foremost institutions of criminal law, and they are evaluating the guilt or innocence of particular individuals that stand trial. And so therefore by nature they tend to only apply and interpret norms that are very unambiguously accepted as criminal. And so in the main, the ICTY and other similar tribunals have not really sought to stretch the envelope of protections in this area. Instead, they tend, if anything, to reinforce or stay within the purview of doctrine as we understand it. And in that regard, and given that my hosts are the ICRC, there is a little bit of a strange chicken and egg phenomena that goes on between the ICRC and the ad hoc tribunals, in the sense that in order to ascertain what the state of the law is at any one time, we tend to look to the ICRC and its commentaries, and we were delighted that it undertook a study of the scope of customary international law, and we were waiting for this with bated breath. But at the same time, in finding support for the customary nature of many of these principles, that very same study tended to quote from our jurisprudence. So it was a little bit of, I think, a perfect endless loop in a way. But I think, I guess the purpose in mentioning this is just simply to say that in general terms, these tribunals are not able by their nature and mandate to take doctrinally daring or revolutionary statements on the nature of this, principally because of the presumption of innocence and the principles of legality that accused persons before these tribunals enjoy. The second is more subtle, but nonetheless is worth drawing out, in that the prosecutors in these tribunals bear a huge amount of discretion in terms of what cases to prosecute or not, and in general terms they are navigating in territory where there is an absolute plethora of candidate cases for consideration. The result of that is generally these prosecutions tend towards those that are unambiguously directed not only against civilians but against multiple civilians. I mean, if you like, where they're a bit of a slam dunk in terms of legal responsibility. In situations where it's even arguable that a civilian or an individual might have participated in hostilities and therefore created ambiguity as to whether he or she was a legitimate target, that would generally be a bit of a red flag as to let's not indict here. So as a general matter, we don't have a huge number of cases that seek to interpret these provisions in any great detail. But nonetheless, I'm going to provide a glimpse at 3 or 4 cases that have nonetheless adjudicated the scope of direct participation in hostilities, as well as the supporting and reinforcing principles that surround it, such as the principle of distinction, the general prohibition against directing attacks against civilians, etc. And interestingly, they refer to siege-type situations. The cases that are most interesting in this regard are the Galic case, and to a lesser extent the Dragomir Milosevic judgment, which were against military commanders responsible for the siege of Sarajevo between 1992 and 1995, the case of Pavle Strugar, which concerns the very peculiar bombardment of the UNESCO-protected town of Dubrovnik in October 1991, which is really the very opening theatre of the conflict in the former Yugoslavia. I'll also talk briefly about the Srebrenica, one of the Srebrenica judgments in Orich, which was actually one of the few cases launched against one of the accused, a Bosnian Muslim defender of the town of Srebrenica under siege, not because it has anything interesting doctrinally, but it gives a really interesting glimpse in terms of the types of quasi-combatants that tended to emerge in an utterly desperate situation, such as the siege of Sarajevo, just prior to the fall of that town, where essentially the population was reduced, was firstly confined into this tiny territory and were reduced progressively into more and more desperate situations, and where basically all resources available were mobilized in the rather, at the end of the day, rather futile attempt to stave off devastation. But that said, it probably should also be noted that in general terms, the conflict in the former Yugoslavia is not really pushing the envelope in terms of the complexity of the conflict in question. Many of these violations were committed by basically mortar attacks, although one document that I will highlight in passing is the fascinating but little known report of the Office of the Prosecutor of the ICTY in relation to the NATO bombardment of the former Yugoslavia. That was really the ICTY's one and only foray into more modern forms of combat, and in particular norms surrounding aerial bombardment. But in the main, it should also be borne in mind that the jurisprudence of the ICTY is limited to extremely low-tech warfare by modern standards. The other feature is it's not accidental that I'm referring almost exclusively to the ICTY in this context. Because of the predominant focus of all of these tribunals on mass atrocities against civilians, the overwhelming emphasis tends to be on charges under the heading of crimes against humanity and genocide. However, the ICTY has a tiny subset of cases that are directed towards the conduct of hostilities. However, the ICTR in general, well, firstly it's empowered only to try Common Article 3 offences, and in general terms had huge difficulties in having convictions for war crimes to stick due to the perceived lack of a nexus between the Rwandan genocide and the parallel armed conflict. So therefore, in the main, the ICTY, our jurisprudence on these types of issues is uninteresting. Similarly, the Khmer Rouge Tribunal really did not tend to pay any heed whatsoever to the context of the armed conflict that existed, other than to establish the necessary threshold elements for that. And so that is why I am focusing almost exclusively on ICTY jurisprudence, and it's not some peculiar sort of national favoritism on my part. But let's, I'm going to do two things. I think firstly I'm going to situate the notion of direct participation in hostilities within the legal framework of international humanitarian law, and I'll do so in a way that you'll need to beg my indulgence. It's a fairly basic summary, and then I'm going to move into to a closer examination of two or three of these cases that I mentioned that sought to apply these principles in practice. So basically, the first point to note is that participation in hostilities is interpreted rather broadly as I guess in a nutshell, means and methods of injury to the enemy. There is no uniform technology used in relation to hostilities. Instead, the relevant instruments of international humanitarian law tend to refer interchangeably to concepts such as military operations, warfare, armed conflict. The latter, of course, being differentiated from insurrections and riots and other forms of internal disorder, and that lower threshold becomes relevant at a certain level as well, and I'll return to that at a later point. Conversely, direct participation in hostilities refers to the quality and degree of an individual's involvement in those hostilities. The reference to direct implies that it follows from that it's thought that indirect participation in hostilities is therefore insufficient to remove the protections enjoyed by civilians. This is one of the few norms where happily there appears to be no differentiation whatsoever between international and non-international armed conflicts. As the Strugar appeals judgment noted, the concept of active participation in hostilities under Common Article 3 appears to be more or less synonymous with the notion of direct participation within hostilities under AP1. Now, as we mentioned in the previous discussion, protection is lost only for such a time as civilians take an active part in hostilities, and that once this participation ends, civilians can no longer be attacked. It also does not follow that even if protection is lost, that all protections are therefore removed. The general norms of the laws of armed conflict will continue to apply, and it will merely be that perhaps these civilians so participating in hostilities will perhaps enjoy instead the protections that combatants traditionally enjoy. It also follows that where individuals are participating in violence or instability in a national territory, there's a risk that unless the threshold for the existence of an armed conflict is actually satisfied, and that the entire protective framework of the law of international humanitarian law won't apply at all, and instead what you're dealing with is a domestic law and order situation of an individual participating instead in some form of mass criminality. So that I think is another caveat that's useful to bear in mind for a moment. So in terms of this notion of direct participation in hostilities that serves to lift civilians from their otherwise protective cocoon within international humanitarian law, there's effectively three issues that have arisen, and I think there is no institution globally that has demonstrated the conundrum under each that has done it better than the ICRC. But I think the first issue that arises is at what moment in time does direct participation in hostilities begin and end? What type of participation suffices, and where does it begin? The position of the ICRC in its interpretative guidelines is that it's only concrete and preparatory measures that serve to lift those protections. So it's only, for example, deployment in combat, or deployment which will actually qualify, and that protection will resume as soon as that individual terminates his or her engagement in hostilities. The opposing view, however, is that perhaps this is somewhat artificial, and that it may make more sense to view participation in hostilities as being a sort of continuum, provided that participation has some form of causal connection between the hostilities in question and the participation. Arguably, the protection should be lifted. Take the example of an individual who goes to the effort of acquiring materials to build an improvised explosive device. Arguably, everybody would agree that actually putting the device together, deploying it and exploding it would be direct participation in hostilities, but one could possibly see the entire duration of that individual's engagement to bring about that act as perhaps one form of continuum. The other issue that may arise is what about individuals who form part of some form of vague non-state organised or quasi-organised group? Are they directly participating in hostilities? Again, sort of the doctrine in this area is far more advanced than any example I could point to from the ICTY's practice. But again, the framework suggests that either one could consider that individual, that a member of an organised group that nonetheless forms part of a belligerent's armed forces to clearly satisfy the criteria of taking part in hostilities. The opposing view is that members of an organised armed group must either be regarded as organised criminals retaining their civilian status, or to the extent that this violence triggers the threshold of international humanitarian law, that some form of separate armed conflict comes into existence between that group and the opposing side. Let me maybe make these sorts of issues a little bit more concrete with a reference to the Srebrenica situation and the Oric case. Basically, Nasser Oric was a military commander who sought to mobilize the mainly male population of Srebrenica. At the time it was besieged by the forces of the Yugoslav National Army. In the period before, the town was overrun, and a column of, and the men and the women were separated, and a column of men were formed, the vast majority of which were executed. The Orich judgment describes the resultant Bosnian armia that was created as follows. From its inception, the ABIH sought to provide its members with means of identification such as uniforms, badges and insignia. In the Srebrenica area, however, very few individuals possessed a complete uniform in 1992. Before and after the arrival of this brigade in the area in early 1992, most Bosnian Muslim fighters wore makeshift or parts of the JNA uniforms, which is actually the opposing side. To make up for the lack of adequate clothing, civilians sometimes wore parts of uniforms, and there was evidence to indicate that during some attacks, fighters wore coloured ribbons around their heads or arms for identification purposes amongst themselves. The prevailing conditions then were also far removed from what one would expect a fighting force to typically operate under. For instance, most fighters resided with their families or in makeshift accommodation. Further, participation in all fighting groups within the Srebrenica area was voluntary, in the sense that no formal mobilization order was ever implemented, but once an individual chose to fight with a particular group, he normally aligned himself with that group's course of action. So basically it was, if you can imagine it, it was a situation of complete chaos and disorder, with effectively the defenders trying to utilize whatever resources it had. Some rudimentary attempts seemed to be made to allow some form of compliance with the principle of distinction between combatants and civilians, but it's extremely unclear as to at what point even an armed unit was formed. As a result, the tribunals have tended to steer away from entering convictions in relation to such crimes. This was carried over even after the fall of Srebrenica, when the males of military age or just beneath that were organised into a column, organised themselves into a column and sought to escape the encirclement of Srebrenica. They placed their most fittest men at the head of this column and armed them in the hope that they would perhaps facilitate the maximum amount of survival of these men, but as we know, the vast majority of them didn't survive. The Office of the Prosecutor, because of the inherent ambiguity with this situation, made an affirmative decision not to treat any attacks against that advancing column as a breach of the law at all. Instead, the ensuing Srebrenica cases focused entirely on the wholesale massacre of males of military age once they had been captured.